Hello viewers, welcome to my legal class. This is Chandrakala. In this session, I have to discuss about tortious liability of the state. A tort is a civil wrong arising out of the breach of civil duty or non-contractual obligation. A state is not a living entity but a legal entity. It cannot function without human agency. The state has to act through its servants. So, the state can be held vicariously liable for the tort committed by its servants. The state liability was started when the proverb res non potest pecare means the king can do no wrong was started to lose its importance in the view of public. In England, it was the statute, that is, the Crown Proceedings Act 1947, by which the state was made liable. But in India, there is no such kind of statutes for the liability of the state. Our constitutions provide provisions. Article 300 provides that all actions of the Union government are discharged in the name of Union of India, and all actions of the state government are discharged in the name of the respective states. The clause 1 of the Article 300 provides that the liability of the union and the state government is same as that of the dominion and the provinces of our country before the commencement of the constitutions, subject to legislations of the parliament or the state legislature. To know the liability of the dominion and the provinces, we have to go back to understand the Government of India Act 1935. Under that Act, Section 176 provides provisions. It is linked to the same remedies against the Secretary of State in Council as he might have had against the East India Company if the Government of India Act 1935 and 1858 Acts has not been passed, by which the crown assumed sovereignty. At, uh, at that time, no differences was made between acts committed by the East India Company in its political capacity and acts done by it in exercise of its commercial activities. The situation changed after the leading case, that is, Peninsular and Oriental Steam Navigation Company versus Secretary of State for India. It is the case of 1861. In this case is the first case which brought upon the differences between sovereign and non-sovereign functions of the state. What are the sovereign functions? Sovereign functions are those are done only by government, like defense of the country, foreign affairs, etc. Non-sovereign functions are those which are done by government as well as private individual to make some profit, like trade, construction, transportation, etc. The servant, what happened in the case Peninsular and Oriental Steam Navigation Company's case, the servant of the plaintiff company was traveling in a horse-driven carriage belonging to the plaintiff company, while the carriage was passing near the government dockyard. Certain workmen employed by the government negligently dropped the iron bars on the road. The noise so created scared the horse, and injuries sustained by horse along with the servant of the company. The plaintiff company filed a suit for the damages caused by the negligent act of the government servant. The Supreme Court of Calcutta held that the maintenance of dockyard is a non-sovereign function. Government was held liable. Another important case, that is State of Rajasthan versus Vidyavati. This is 1961 case. A jeep driver, a jeep was owned and maintained by the state of Rajasthan for official use of collector of a district. Once the driver of the jeep was taking back it from the workshop after its repair, by his negligent and rash driving knocked down the pedestrian and caused injury to the pedestrian called Jagdish Lal, and he died subsequently. His widow, called Vidyavati, sued the state government for damages. Supreme Court held that the state was vicariously liable for rash and negligent act of the driver, as the act of driver was not a sovereign function. Another important case is Kasturi Lal versus State of UP. This is 1965 case. What happened in this case is that a certain quantity of gold and silver was seized by police from Kasturi Lal on the suspicion that it was stolen property, put him in jail, and they put all the gold in a locker. After inquiry, they realized that he is a goldsmith and all gold belongs to him only. They released him, and when they wanted to give him back all the gold, they realized that gold is misappropriated by the head constable, who fled to Pakistan. A suit for damages was filed by Kasturi Lal, but court held that the police were exercising sovereign functions. Arresting a person and seizing property are sovereign powers. So, state is not liable for such tort, and the Kasturi Lal didn't get any compensation in this case. This rule is overruled in N. Nagendra Rao and Company versus State of Andhra Pradesh. In this case, the court observed that no civilized system could permit an executive to play with the people of the country and claimed to be sovereign immunity. In the modern sense, the distinctions between sovereign and non-sovereign does exist only in limited cases where the statutory authority act as a delegate of such functions for which it cannot be sued in a court of law. It is evident in the Rudal Shah versus State of Bihar. In Rudal Shah case, it was Rudal Shah was detained illegally in prison for more than 14 years. In Saheli versus Commissioner of Police, the state was held liable for the death of 9-year-old child by police assault. In Neelabati Behra versus State of Orissa, the court awarded compensations to the petitioner for the death of her son in police custody. So, the sovereign immunity is available only for the rare and rarest cases. Now the state is held liable for so many its acts. The court expressly held that principles of sovereign immunity does not apply to the public law remedy under Article 32 and Article 226 for the enforcements of fundamental rights. Kasturi Lal case is confined to private law remedies only. Lastly, we can conclude in the light of above discussions that the state today undertakes a plethora of activities under the umbrella of a welfare state, such as transportation, trading, construction, etc. It would be unfair to immunize the state for any tort committed by its employees during the course of employment. Sovereign immunity as a defense can never be available where the state was involved in commercial or public activities and it interferes with the life and liability of a citizen. The state must be legally and morally bound to compensate the victim for the wrong committed by its servants. This is the end of this sessions. We will meet you in the next class with the next concept. Thank you. Bye.